This is very confusing, which is usually not good for plaintiff. I kind of understand about the defendant damaging the car, but it seems that this case was already tried or something. Let's see if the defendant can clear up this mess.
Well, what do you have to say about this, Ms. Lowry?
Your Honor, let me shed some light, because the young lady here, like she said, she's just coming in the second time. I have went to mediation, and I've also went to court. This case here was tried in front of Judge Gruberg, is it?
Judge Gruenberg?
Right.
Okay.
And they did not show up for court, and it was awarded to me in my favor, the case was. I sued them for, originally, when I rented the car, and I have all my paperwork here, I paid insurance on the car. I've rented from Lakeside numerous of times, and I've paid for insurance that is $25 a day for car insurance. It's the only insurance that they have to offer their customers, and I pay that. This particular incident they're talking about, I have rented a car for a week, and I have it here. The whole total came, and I paid $25 a day for insurance. The bottom spoiler, they had a car with a low bottom spoiler. Well, this was the first snow, and I hit a pothole. I go to them, they tell me it's not included in that damage was not included in the insurance. Well, I have their policy here that states that it says all damage, it says rentee accepts or declines collision damage waiver for rates listed above, which is $25 a day. Damage option below, by accepting the waiver, rentee accepts full responsibilities for all loss and damage to the rented vehicle over $500 per occurrence, regardless of cause and loss of uses due to the accident or negligence. So, to me, what it says is, if anything happened, I would be responsible for whatever over $500. Well, they said the damage was $795, which would have left me at $295 that I owe. Initially, when I rent from them, they hold my credit card for $250 for a deposit. So another young lady employee named Sue, she's the one that did this. She told me, she said, well, I don't know how much damage, when I brought the car back, she said, well, I don't know how much damage is going to be, but I'll call you back and let you know. I said, okay. Then she called me and said, it's $795, but it's not included. I'm like, why is it not included in insurance? You mean to tell me I'm paying $25 a day and it doesn't cover anything, but you don't offer anybody anything? If you had something better, I would buy better. The following Monday, the banks weren't open because it was Martin Luther King's birthday. I'll never forget it. When I go to get a ride to come down there, I go to get the money to pay them. I look in my account. They done went in my account and took $800 out of my account. They done took all my money. I got insufficient fees. I have all these fees that I incurred. I had to borrow money to pay people everything. So when finally, then they sent my bank a bogus letter stating that it wasn't covered because my insurance stopped on the 16th of December. I didn't bring the car back to the 17th. Sorry, that was a fib because I have it here. 6 days I rented that car from. I brought it back the 17th. I paid from the 12th to the 17th. I paid to have my car. It was insured when I brought it back. That's one thing. After that, then my bank found out that I was, I told the truth. That's why they had to give me my money back in my account. When we went to mediation, when we went to court, they didn't show up. The judge awarded me the rest of my fees. All the fees that they caused me, that's what the rest of the money. When I was in mediation, they tell me in mediation, and that's what I said. They opened this case back up like a new case. It was told to me, once I was granted this, the judge granted it to me, that was the end. They didn't even come back for whatever time they have to appeal it. They didn't even do that. They waited months later, and they're bringing this up like a new case. I'm totally stressed out. I'm sorry, Judge. I'm a full-time student. I have research papers I'm doing. I have a letter from my instructor where my grades are reclining. I've missed 2 scholarships because I'm dealing with this. It's like a haunted thing. When I went with her in mediation, she didn't even know what went on the first time. In mediation, we're talking. Then she gets up, the mediator guy there, she abruptly marked on my paper. I have it right here. This paper here. I thought she was coming after me with a pen. She ended up slamming on my paper. And this I'm sorry. I was making that noise. I'm sorry. And this is the mark that she did on my paper. I'm thinking she coming. Then she ran out and stormed out of mediation because she really didn't understand what was going on. I don't understand. It's like their people did something wrong. They want me to pay for their wrong. you know, harassing me. I need this out the way. I don't owe them anything. In mediation, they tell me in mediation, what goes on in mediation, once we leave, it's non and void. You're not supposed to say nothing. When they come this time for this case, they're using this word, they were calling me double dipping in mediation. I thought that was very much slander. I didn't double dip nothing. I'm not trying to do nothing wrong. I followed every line. I rented a car, I got insurance, I did everything I was supposed to do, and now I'm constantly coming back to court for something like this. I don't understand it. Everything, they really don't have nothing. Everything she say, I can counter it with the stuff here. She doesn't even really know what she's talking about.
Ma'am, let me see the case that you filed with Judge Gruenberg. Let
Here,
me
go
see
right
the
here.
affidavit claim.
Your Honor, I have papers here too, if you'd
Well,
like to
just
look
one
at.
second. Let's start with
Okay.
that. I want to see what you filed with Judge Gruenberg and if you got a judgment.
This is the one, that's it here. That's one judgment there. And then, this one here is, this is the first one I did. I think this is the first one I did. I just got the court thing here stapled to it. I don't know if he.
This is a judgment dated June 29th of last year.
Yes.
For $818.
Yes,
A case that you filed against Lakeside Car Rental.
yes. That was the first claim that I did
All
with
right.
them.
That was a small claims case,
Right.
right?
Uh-huh.
Okay. All right. Affidavit and claim. Sharon Lowry versus Lakeside Car Rental. This is the one.
Mm-hmm.
And it says, reasons for claim, Lakeside Car Rental charged me for car damage that was covered by their insurance, in which I paid $25 a day for, then made an unauthorized withdrawal of $809.48 from my account to cover that. You sued for $1,503.41.
Right.
Why did you sue for that amount of money?
Because that was it. That was, oh, I'm sorry. That was the money they took out, plus all the fees, my insufficient fees. When they took that out of my account, I had everything that came through was just getting insufficient funds. I had to borrow money to keep myself from going further in debt, and then all the court fees and stuff like that. That's what the other is for.
That's almost $700.
Your Honor, I had to borrow money. I have all these things, all these insufficient fees. I have bank statements galore from where I had, because that was like a business account. I had to pay people out of that account, but when they took it, I had no money to pay anybody.
Well, it seems that there are two cases, and the law is very clear. Once a case goes to court the first time, it can't come back to court a second time. Now, that makes sense. The only kicker here, are the issues really the same? I kind of think I have an idea of where the judge is going to go with this one, but let's see what the judge says.
See, the problem you have, ma'am, is this first case. You can't simply sue again because you don't like the judgment, okay? There is a doctrine, a legal doctrine called res judicata, okay? That's Latin. It means the thing has been decided. And what that means is once a judge or a jury decides something, then it's done.
Okay.
You can't simply try again. In other words, you can't sue a person, lose, and then sue again, and then keep suing again and again and again until you win. Once something's been decided, that's it, because litigation would never end. It would go forever and ever and ever. And the problem that your company has, I think, in this case, is that rightly or wrongly, the issues raised in the first case were decided, or the issues raised in this case were decided the first time around when Ms. Lowry filed the case against Lakeside Car Rental.
Okay.
Now, no one showed up from Lakeside Car Rental, apparently.
I believe they did at the mediation.
Okay, maybe at the mediation, but not
Because
at...
Ms. Lori had told them at that time
did not.
she was going to stop it.
No, I did not.
Because she had already
Well-
gotten paid back from the credit card company.
I don't know what she said, but it really doesn't
I
matter.
don't know.
It really doesn't matter, because you had a case, I guess, in front of Judge Gruenberg that dealt with a lot of these issues. And when Lakeside didn't show up and Judge Gruenberg decided the case, then that's it. The determination was already made. If anything, what you would have to do is file a motion in front of Judge Gruenberg to have her relook at the case and raise the arguments that you're raising here in front of her, rather than simply refiling the case all over again. Because what you're really wanting to do is have the case reheard here. And you can't do that. Once something's been decided, it's been decided, even if it's been decided by default. In other words, even if it's been decided by someone not showing up, it's still a binding decision. So I'm going to dismiss this case, not necessarily because I don't think the issues that you're raising are invalid, or that because I think you don't have a case. I really don't know. I would, if I thought, if it weren't for this case filed against you previously, we would be getting into the questions that you're raising here today, and I would make a decision on it. I don't have to really do that. In fact, I can't do that because of the other case. So I don't want you to think that I'm necessarily saying that your claim is wrong. It might be wrong. I don't know. And it would, but the only way for you to litigate this case or to have your issues heard would be in front of Judge Gruenberg, because that's where the case first started. So I'm dismissing the case on a technicality, is I guess what I'm saying, although it's
Can it
an
be
important
reheard in
technicality.
front of Judge Grunberg?
Well, that's what I'm saying. What you would have to do is bring a motion in front of Judge Gruenberg to have her set aside the default judgment that's entered against your company, and that was done, well, on June 29th of last year.
Yeah.
It's already, you know, this is May, so it's almost a year. I don't know if Judge Gruenberg would do that or not. You would have to ask her. It would be up to her to decide whether she wanted to do that. All right? Let me return these documents to you, ma'am.
Yes.
You gave me these,
Your
Ms.
Honor.
Lowry. What?
Is there, what, if, I guess, you know, I know you dismissed the case and that's fine, but if they, you know, for my time and the things that they, is there anything that I can do myself for them dragging me again through a same case again and cause me the stress that I've been through over the same thing that I went through the first time?
Not in this instance, ma'am. I'm
Okay.
not going to award any sort of cost because I don't think there was any bad faith on behalf of Ms. Gabriel in this case. I don't think she understood this sort of technical legal position, which is that you can't refile the case again. She does not, listen to me, she does not understand res judicata. You don't understand res judicata. Maybe now you do, but you didn't understand it until I told you.
Oh, no, I
So
did, that's why I
just-
brought it
yeah,
up.
but just-
Okay,
Ma'am,
all right.
okay, if you would learn to listen, it would be
Okay.
easier. I'm trying to explain it to you, and you really you won't let me do it. She didn't really understand the point that I just made. So she didn't do this, I don't think, because of bad faith. She thought she had a claim and thought that the best way to do it would be to file the case the way she did. So because there's no bad faith on her part, I'm not going to award any cost for you or any other monetary damages for you coming here today. And that's the reason why. Okay? All right, case is dismissed.
Well, the judge is right. You don't get a second bite of the apple. The moral of the story here is if you go to court the first time, make sure you actually go to court, because you're not going to get a second chance. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton.